Contract law explained. Let's get started. For a real estate contract to be enforceable in a court of law in Georgia, it must: is it A, be in writing and signed by the parties? Or B, have a recorded verbal agreement? Could it be C, be filed with the clerk of the Superior Court? Or lastly D, both A and C? The correct answer is A. Here is why. Georgia's Statute of Frauds, which is based on common law, requires that contracts for the sale of real estate be in writing and signed by the party to be charged, the party being sued, to be enforceable in court. Therefore, A is correct. A recorded verbal agreement, B, would still fail to satisfy the Statute of Frauds. While a deed must be recorded to provide notice to the world, the underlying sales contract itself does not need to be filed with the clerk of the Superior Court, C, to be enforceable between the parties. Therefore, D is incorrect. Next question. John received a big promotion, which came with a substantial raise. John would like to add an extra $350 to his monthly mortgage payment to pay off his home loan sooner. What clause should John review in his loan agreement before going forward? Is it A, satisfaction clause? Or B, subordination clause? Could it be C, prepayment clause? Or lastly D, acceleration clause? The correct answer is C. Here is why. John needs to review the prepayment clause C. This clause outlines whether the borrower is allowed to make extra payments toward the principal balance of the loan, and if so, whether any penalties, prepayment penalties, apply. The satisfaction clause, A, relates to the release of the mortgage lien upon full payment. The subordination clause, B, dictates the priority of liens. The acceleration clause, D, allows the lender to demand full payment of the loan balance if the borrower defaults. Next question. Is it a legal requirement to have witnesses present at the signing of a deed, other than a notary in some cases, during a real estate closing when transferring ownership in real property in Georgia? Is it A, yes, at least one person must witness the signing of the deed? Or B, yes, at least two persons must witness the signing of the deed? Could it be C, yes, and the buyer can act as a witness? Or lastly D, no? The correct answer is D. Here is why. In Georgia, the general requirement for a valid deed is that it must be in writing, contain the names of the grantor and grantee, contain words of conveyance, be signed by the grantor, and be delivered to the grantee. Georgia law does not require witnesses for a deed to be valid between the parties. However, for the deed to be eligible for recording in the county land records, which is crucial for providing public notice and protecting the grantee's interest, it must be notarized, acknowledged by a notary public. The notary acts as the witness for recording purposes. Therefore, the statement that no additional witnesses are legally required, D, is correct. Many other states do require one or two witnesses, but Georgia follows the notary acknowledgement standard. Next question. Ayanna Dubois, a chef, rented property in order to run a restaurant in California. Dubois purchased and installed a commercial-grade range, oven, deep fryer, and grill. To comply with safety regulations and protect her staff, Dubois has securely fastened all of this commercial restaurant equipment to the kitchen. Which of the following is a correct statement related to the restaurant equipment Dubois installed? Is it A, Dubois can remove this equipment from the property prior to the termination of the lease? Or B, Dubois can remove this equipment from the property even after the lease is over? Could it be C, because this equipment has been firmly affixed to the property, it is now part of the real estate? Or lastly D, the lessor will determine whether or not Dubois can remove this equipment? The correct answer is A. Here is why. This scenario involves the legal concept of trade fixtures. Trade fixtures are items installed by a commercial tenant for the purpose of conducting their business. The key rule is that a tenant has the right to remove trade fixtures during the lease term, provided that removal does not cause substantial damage to the property. Option A correctly states this right of removal prior to lease termination. Option B is incorrect because after the lease is over, the tenant typically loses the right to re-enter and remove items. Option C is the general rule for fixtures, items permanently affixed, but trade fixtures are a major exception to this rule. Option D is incorrect. The right to remove trade fixtures is a legal right of the tenant, not subject to the lessor's arbitrary determination unless the lease agreement specifically states otherwise. Next question. Which of the following is an example of the government's realty-related police power? Is it A, the SWAT team breaking down the door of a unit in an apartment complex? Or B, a city changing the zoning from industrial to residential in an entire area? Could it be C, a county forcing owners out of their homes through eminent domain? Or lastly D, the state, without the prior owner's permission, acquiring permanent title to realty through escheat? The correct answer is B. Here is why. Police power is the government's inherent right to regulate property to protect public health, safety, morals, and general welfare. Zoning, B, is a quintessential example of police power. Eminent domain, C, is the power to take private property for public use, with just compensation, but it is a separate power from police power. Escheat, D, is the state's power to acquire property when an owner dies without a will or heirs. A SWAT team action, A, is a law enforcement action, not a regulatory property power. Next question. All of the following are examples of lawful private controls on real estate except. Is it A, limiting the size of the American flag homeowners are permitted to fly on their property? Or B, forbidding paint color other than beige on the exterior of a home? Could it be C, promoting diversity through restricting sales to unrepresented races? Or lastly D, banning people from owning large dogs weighing over 40 pounds? The correct answer is C. Here is why. Private controls, such as those found in Homeowners Association, HOA, covenants, conditions, and restrictions CC and RS, are generally enforceable if they are reasonable and applied uniformly. Restricting flag size, A, exterior paint colors, B, and pet ownership/weight, D, are all common and typically lawful private restrictions. However, option C describes racial discrimination, which is expressly prohibited by the Federal Fair Housing Act. Any private restriction that discriminates based on race or other protected classes is unlawful and unenforceable. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.